Judica County is brought to you by Whitaker and Hamer, attorneys and counselors at law, your law firm for life.
Welcome back into Judica County Radio. Your host, Josh Whitaker and Joe Hamer, managing partners, Whitaker and Hamer Law Firm. Offices located conveniently for you in Raleigh, Garner, Clayton, Goldsboro, Fuquay-Varina, Gastonia, and in Moorhead City. Whitaker and Hamer, your law firm for life. I'm Morgan Patrick, consumer advocate. Josh, we are again having some of your all-star attorneys joining us on the program. Who's up next?
Up next, we have attorney Ashley Penner. She is with our firm, has been with our firm for a long time, handles estate planning and trust.
Today, our theme has kind of been talking about how you can use your attorney to kind of do some planning. We've talked about business planning. We've talked about family law planning. With Ashley, we're going to talk about estate planning and later on in the show, talk about, well, what happens if you don't do estate planning? What becomes purview of the court, public information? What do you have to deal with if you don't do your planning? And so, Ashley, in that vein, I know one of the things I wanted to talk to you about today, one of the things I wanted to ask you about is this planning process, and what you can do to keep your information private, to keep your stuff out of the purview of the court. None of us ever want to have to rely on a clerk's order or a judge's order or get our assets caught up in an estate probate or an estate contest or something like that. And people in that vein, we're going to talk about, your estate planning, a will, which I think everybody's pretty familiar with what a will is and what a will can do. That doesn't get you out of probate versus a trust, which a carefully crafted and managed and a monecured trust would keep you out of possibly probate. So that's where I'll start it with you, kind of the advantages of, what is a trust and kind of the advantages of a trust.
Yeah, the trust is a legal document that, of course, you would create as a part of the estate planning process. It can hold assets during your lifetime and then speak to or control what happens to those assets, how they're distributed or how they're held in trust, who they can benefit after your death. And it's the ability of the trust to hold those assets while you're still living that gives you that probate avoidance. They've already been transferred into this legal entity, so to speak, that you've created. You've already designated someone who we call the trustee that's going to be in control of the assets after your death. And it streamlines that process so that you do avoid the probate process or administration process where a clerk is involved in making sure that what you've said in your will is honored in the administration.
So when I was growing up, I think I was trying to think about earlier today, the first time that I ever heard anybody talk about a trust. And I think the first two times that I can remember hearing anybody talk about a trust was, who was the rich guy on Gilligan's Island?
Oh,
who was his name?
Howell.
Mr. Howell.
Mr. and Mrs. Howell, yeah.
And or Beverly Hillbillies. I feel like I came up on Beverly Hillbillies a couple of times. But and maybe that's why I think about trust. And I think about they're just for the rich people. They're just for people with like tons of assets, and that's really not the case.
No, yeah, I definitely grew up thinking the same thing. Anytime I heard them, of course, no one in my family ever had a trust, nor have I ever been the beneficiary of a trust. So most of my actual knowledge of it comes from law school, like most of us probably. But it is certainly not reserved for folks, that have massive amounts of wealth. I tell a lot of my clients, if the only thing you end up using your trust for is to hold your real estate, you have done yourself and your family a significant service. Because again, it's going to really trim up what they have to do and how quickly they can do what they need to do, depending on what that is. So, yeah, I've always heard this rule of thumb of, $5 million, should have roughly $5 million in assets before you should even think about or worry with or bother with a trust. And yeah, not the case. It has so much benefit to so many different folks.
And it's kind of one of your biggest estate planning tools. And a trust is basically I think of it as, it's kind of like starting a business, right? You start an LLC, you start a corporation, you're starting, the law sees that as its own, entity, its own thing. And so I'll talk to people a lot about probate assets and non-probate assets, but the trust is like a magic bucket that you can put things in. And a trust isn't going to die. Yep. It may terminate on its own. It can only go on for so many years, but in theory, it's going to outlive you. And that's the convenience of it. It's just kind of oversimplifying and maybe kind of dumb, but I like it as a metaphor. But it's like you put stuff in this bucket and this bucket automatically goes to your heirs.
Yeah.
Right? No one looks in the bucket. No one's going to ask you questions about the bucket. You've got some basic asset protection if someone was going to sue or challenge the way you're distributing your things. So it's like this magic vehicle, and there's tax advantages and there's other advantages too, but it's this magic vehicle to get stuff to your heirs easily. And, you think about it, if you've got a house with equity and you've got vehicles and you've got your 401k and you've got your investment accounts, we may not think of ourselves as having a lot of assets, the average American who might be looking at this, but you've got a lot of assets to protect.
Certainly. If you might have a different stance on that if you're being sued and you start looking at what could become subject to a judgment in the event that one is in place, yes, then you absolutely have a lot of assets. And then, something you mentioned, I think that is also good to point out with the trust is it has so much flexibility because it is that existing entity. It can undergo changes, a little bit more easily than if you're changing how your will distributes your property. There is a lot more rigor involved in the signing of a will than in the signing of a trust, but also the privacy that it brings with it. The fact that, no one's going to be delving around into that document and no clerk is going to be looking over the shoulder of the trustee to make sure that, they've adhered to the rules in the trust. It has the privacy that a lot of folks want in keeping all of their business out of court filings.
And I guess there's certain things we're talking about trust, and I've talked to them as magical about being magical and things like that. There's things trusts don't do that you need your other estate planning documents to do. So one of the things that you pointed out to me before is, if you have a good trust, your will is what we call a pour over will, right? Where the will is just saying, hey, anything that I haven't managed to get into my trust, please give it to my trust. And so that's a pour over will. But there's other things that will can do for you. And actually, you always point out to me, I always overlook guardianship, and so that's an important one to
guardianship for your minor children, right? Yeah, making sure that anyone who's under the age of 18 that you've been in control of saying who they should be with, who should be caring for them. If you don't have a will, right, you're leaving it up to the courts to determine with whom they should be placed. And also, sometimes, unfortunately, there might be people who as much as you want other folks to be the guardian of your children, there are folks you don't want to be guardian of your children. And the will is a place where we can make that known as well. If you don't leave a document behind that addresses that at all, it could be the person that you ultimately did not want to be guardian of your children who goes and applies for that guardianship. And now they are being raised by someone that, in your mind your children would never live with. So a trust is certainly a very important estate planning and can be kind of the primary estate planning vehicle, but it can't do everything that we need. So I tell a lot of my clients, you might have a will and not have a trust, but if you have a trust, you should still absolutely have a will, because aside from addressing guardianship, let's say you don't have minor children anymore, you go out and you acquire assets. Let's say you've gotten this trust prepared and you're working on getting everything transferred into it, and then something happens, sudden death, and you don't get a chance to continue in your funding of this trust mission. You've still got a valid will that's going to get everything there.
Yeah, I talk to a lot of clients who definitely think it's an either or situation. Like, well, I've already got my trust or I've already got my will, but you really need both of them. Mm-hmm. And the will handles some things you can't handle with the trust, and there's also kind of a fail safe there. So that does come up. I know there's other ways. We're talking about the trust being this magic bucket, which can make otherwise a probate asset, an asset that would have to go through probate, non-probate, private. But there's other ways to make probate assets non-probate.
Yeah. Yeah. So, you might have things like bank accounts, life insurance, retirement plans. And on all of these assets, we counsel our clients, you want to make sure you have beneficiaries designated, a primary beneficiary and a contingent. And maybe, if you're a married couple with children and you have this trust, you're going to name your spouse as the primary beneficiary, but then you name the trust as the contingent beneficiary. But even on things like bank accounts, you can name a payable on death or transferable on death beneficiary. And these are ways that you can ensure that those assets avoid that probate process. There's not going to be a significant delay in being able to access those funds. Of course, you'd have to have a death certificate. We don't want people, our designated beneficiaries, being able to show up at the bank and say, hey, she died. Can I have her money, right? We want them to show that proof through death certificate. But that's going to be a much shorter process than going to the clerk's office and setting up that estate, that probate estate, and then transferring the account into an estate account and then documenting for the clerk what funds were in that account. That's going to hold up things. And particularly if we have a situation where, parents are lost and there are children that, will have needs that need to be tended to, it'll allow for much less disruption in the basic maintenance and care for those minor children.
Yeah. Well, Ashley, I think that's a good discussion today, kind of on this using your attorney to plan things out for you to make your life easier, to keep you out of litigation, to keep you out of the court, keep you out of the clerk's office. So I appreciate that. The first step in estate planning is to give us a call. If you call Whitaker and Hamer, if you call our law firm and you want to talk about estate planning, you're going to end up talking to Ashley. And that's for good reason. She handles many, many, many of these every month. And she's a good place to start. And we'd be happy to help you with that. But Ashley, I know we'll talk about this again. So we'll see you before too long.
Absolutely. Looking forward to it.
That's Ashley Pinner. Again, estate planning with Whitaker and Hamer. We are again visiting with the all-star team of attorneys at Whitaker and Hamer, hosted by Josh Whitaker and Joe Hamer. Again, hitting a lot of different questions that the firm gets quite a bit of. And folks, if you've got any situation you're facing and you need answers to those questions, you can always call Whitaker and Hamer, 800-659-1186. That's 800-659-1186. Leave your contact information, briefly what the call is about, and an attorney with Whitaker and Hamer will be in touch. And you can email your questions to the show. We'll answer them on a future broadcast. info@judicacounty.com. When we return on Judica County Radio, yes, we have another attorney, and she's very familiar. Cassandra Nicholas joins us. It's about estate planning. We're looking forward to this discussion. Again, that's coming up on the other side.